the MOOC on human rights in India. Today we are going to discuss the module on Directive Principles of State Policies. The Directive Principles of State Policies, or DPSPs, are enshrined in Part 4 of the Constitution under Article 36 to 51. The DPSPs are a truly novel feature of the Indian Constitution, as there are very few countries around the world which have set down aspirational goals for the government within their own constitution. The concept of DPSPs was borrowed from the Irish Constitution. Now, the Directive Principles of State Policies are actually guidelines which are given to the government, both legislature and executive, which must be kept in mind while formulating the laws and policies of the country. These principles lay down certain high ideals for justice, political, social, and economic equality, and fraternity amongst the community. They range from principles like distribution of wealth, providing living wage to the people, right to work, right to education, maternity benefits, protection of environment, and protection of the architectural heritage of India. Now, even though there are these high ideals prescribed in the directive principles, they are non-justiciable in a court of law. What this means is, a person cannot approach a court of law to enforce the principles which are laid down in Part 4. Also, if there is a law that is in violation of a directive principle, just because of the fact that is in violation of the directive principle, it cannot be held to be void. So there is very little legal force behind these principles. At the time of framing of the Constitution, the members of the Constituent Assembly were faced with a dilemma. There were certain rights, both civil and political and economic and social, which were taken to be protected. There was a commitment to protect these rights. However, given that India was going to be a newly independent country and would have to face poverty and lack of resources, certain principles which were aspirational in a sense of building a welfare state, but which probably could not have been provided at the very onset, they were laid down in the directive principles. So there was a particular thought process that went into the idea of making these guidelines, though giving them as a direction to the future governments, but not making them enforceable in a court of law. Some critics believe that the directive principles are merely pious expressions and don't have any force of law. The eminent members of the Constituent Assembly, like Sir B.N. Rao, believed that they were in fact educative measures which would provide a certain direction for the development of the country. The objective was to develop India as a welfare state. In a welfare state, it is the responsibility of the state to ensure health and other certain benefits to the citizens, especially to those members who are of a financially or of a socially weaker section of the society. Hence, the directive principles have been framed in such a way. Dr. B.R. Ambedkar believed that even though there isn't a legal force behind them, there is definitely a political sanction or a political justiciability. That means that the directive principles can be seen as guidelines which the electorate would keep in mind while judging whether a certain government or a certain political party should be voted in power again. These are the guidelines through which the progress of a government can be checked. Also, according to Dr. Ambedkar, the directive principles were very similar to the instrument of instructions which were given to the Governor General and to the various governors in India under the Government of India Act of 1935. Now, even though they are non-justiciable, an important feature of the directive principles as recognized by the courts is that they are useful in the interpretation of various statutes. So, any statute must be interpreted in such a way that there is no conflict between the statute and the directive principles. Over the years, the courts have also come to recognize that the directive principles help in understanding the scope of fundamental rights as well. Now, the relationship between fundamental rights and directive principles is an important topic of discussion. fundamental rights are negative liabilities that are put on the state. So, for example, these are guidelines or these are instructions to the state of things which should not be done. For example, the state shall not discriminate between people. The state shall not interfere with the life and liberty of a person. On the other hand, the directive principles are positive obligations that have been put on the state. For example, these are the measures like providing the right to work or providing maternity benefits, which have to be given by the government for a person to be able to enjoy the right. Now, of course, fundamental rights are enforceable in a court of law. And as we just discussed, DPSPs are not enforceable in a court of law. So now the question arises, what happens when the fundamental rights come in conflict with the directive principles? This issue has come before the Supreme Court as early as in 1950s. There has been a certain evolutive take of the Supreme Court on this point. The first case in 1952, State of Madras versus Champakam Dorai Rajam, dealt with this issue. The government had reserved certain number of seats in a college on the basis of religion and caste. Now, this was in conflict with Article 29, Subclause 2. However, the government's argument was that this was an effort to give effect to Article 46, which provides for right to education for the weaker sections. The Supreme Court held that wherever there is a conflict between Part 3 and Part 4, Part 3 would prevail. So that means that if there is a conflict between fundamental rights and the directive principles, the fundamental rights would be given more importance to, and the fundamental rights would precede over the directive principles. In Re Kerala Education Bill case in 1957, the Supreme Court came up with a concept of harmonious construction between the fundamental rights and the directive principles. In this case, the Supreme Court ruled that there is no inherent conflict between the directive principles and the fundamental rights. They are essentially complementary and supplementary to each other. So they must be read in such a way that there is no conflict that is created. So even though the directive principles cannot override the fundamental rights, the fundamental rights must be read in the light of directive principles. In 1967, in I.C. Golaknath versus State of Punjab, the Supreme Court held that the fundamental rights cannot be overridden to give effect to the directive principles. However, the Parliament in 1971 came up with the 25th Amendment to the Indian Constitution. Under the 25th Amendment, Article 31C was added to the Constitution. There are two parts to Article 31C. The first part says that if there is a law that is created which gives effect to the directive principles laid down in 39B or 39C, such a law cannot be called into question or cannot be held void on the basis of violation of Article 14, Article 19 or Article 31. The second part of Article 31C stated that if there is any law which mentions in its objectives that it is being promulgated to bring into effect the directive principles laid down in 39B and 39C, such a law is going to be beyond judicial scrutiny. This amendment was challenged in the landmark judgment of Keshwanand Bharti versus State of Kerala in 1973. The Supreme Court held that even though the Parliament had the power to amend any part of the Indian Constitution, they could not interfere with the basic structure of the Constitution. Keshwanand Bharti does not lay down completely what the basic structure of the Constitution is. However, it stated that judicial review was one of the important components of basic structure. And since in the second part of Article 31C, Judicial review, there was a complete ban on judicial review for any law which is being brought in to give effect to the directive principles. That part of Article 31C was struck down. The Parliament struggle continued, and in the 42nd Amendment in 1976, the purview of Article 31C was expanded. Article 31C now read that any law which is promulgated to bring into effect not just the directive principles of 39B and C, but any directive principle cannot be called into question for violation of Article 14, 19 and 31. In the landmark judgment of Minerva Mills, the Supreme Court finally settled the conflict between the fundamental rights and directive principles. In this particular case, the court held that fundamental rights and directive principles are two important components of the Constitution and must be read harmoniously with each other. Article 31C was also changed back to its pre-1976 position. So, Article 31C as it reads now is that if there is any law which is created to bring into effect Article 39B or 39C, it cannot be held void if it is in violation of Article 14, 19 or 31. So it cannot be held void for the reason of violating Article 14, 19 or 31. Minerva Mills settled the conflict to a large extent between fundamental rights and directive principles by holding that both need to be read together and there needs to be a harmonious outlook towards them. Over the years, the government has been able to bring to effect some of the directive principles. For example, the government has promoted the creation of village panchayats, and now there are over 2 lakh village panchayats in the country. Also, under Article 47, which provides for an increase in the standard of living, the government has rolled out several schemes like the Integrated Rural Development Program and the Integrated Tribal Development Program to provide nutritional value to the people living under the poverty line. Also, under Article 39A, right to work has been recognized as an important directive principle. This has also been recognized as part of right to life by the Supreme Court in the Olga Tellis case. In the 86th Amendment in 2002, Article 45, which deals with right to education, has been recognized as part of right to life under Article 21A, which now ensures elementary education to all children. So to sum up, the directive principles are guidelines which are provided to the government for the creation of a welfare state. Even though they are non-justiciable, they have been recognized by the Supreme Court as important tools for interpreting not just statutes but also the fundamental rights. The relationship and the conflict between the fundamental rights and the directive principles has been resolved in a manner in which both will be seen and read harmoniously together, and neither can be given precedence over the other. Over the years, the government has been able to fulfill some of the provisions which have been laid down in the directive principles, but we have a long way to go in front of us. Thank you.